Morning, everyone. This is the Committee of Bar Examiners meeting today on October 13th. We're opening the meeting at 9 a.m. My name is Michael Cow. I'm the new incoming chair of the CBE. And Devin, could you go ahead and do a roll call vote?
Yes. Dr. Bolton?
Here.
Robert Brody?
Here.
Dr. Cow?
Here.
Alex Chan?
Here.
Jim Efting?
Here.
Kareem Gangora? Paul Kramer?
Here.
Larry Kaplan? Alex Lawrence?
Here.
Esther Lynn? Justice Messiwala? Here. Bethany Peak? Ashley Silva Guzman? Here. Judge Reyna? Here. Vince Reyes?
Here.
Alan Yokelson?
Here.
We have a quorum.
Thank you so much, Devin. We'll start with agenda item number 1B, which is approval of the August 18th, 2023 meeting. Are there any questions or comments on that from anyone? Okay, may I get a motion?
This is Robbie. I'll move to approve those minutes from the meeting.
Thank you,
This
Robbie.
is
May we
Vince.
get a second?
Yeah, this is Vince. I'll second.
Okay, thank you, Vince. Can we go ahead and get a roll call vote on that then, Devin?
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora?
Yes.
Thank you.
Okay, thank you. The next item on the agenda is the approval of the September 1, 2023. Yes.
I don't think Devin is done yet.
Oh, I'm sorry.
Sorry. Paul Kramer?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence?
Yes.
Esther Lynn? Justice Messiwala?
Abstain.
Public meeting.
Bethany Peak? Ashley Silva Guzman?
Yes.
Judge Reyna?
Abstain.
Vince Reyes?
Yes.
Alan Yokelson?
Abstain.
Dr. Cow?
Okay, thank you, Devin. We'll go to agenda item number 1C, which is approval of the September 1, 2023 CBE meeting. Are there any edits or comments on this? Okay, I actually have one. When I was looking it over, when we did the action and discussion on recommendations related to the alternative pathway working group proposal to develop a portfolio bar examination, just a minor edit. When we did the roll call vote on the meeting minutes, it says that there were 13 ayes, and actually there was only 6 ayes. So the number of no's is correct at 3, and the number absent correct is 5. But I think if we can edit that from 13 to 6 for that, if everyone is okay with that. So that's the only edit that I have concerning that. May I get a motion on that?
This is Robbie. I'll move to approve as amended by Dr. Cow.
Thank you, Robbie. May we get a second?
Second. This is Alex.
Thank you, Alex.
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora?
Yes.
Paul Kramer?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence?
Yes.
Esther Lynn? Judge Messiwala?
Abstain.
Bethany Peak, Ashley Silva Guzman,
Yes.
Judge Reyna,
Abstain.
Vince Reyes,
Abstain.
Alan Yokelson,
Abstain.
Dr. Cow.
Yes.
With 10 yeses and 0 nos, the motion passes.
Okay, thank you, Devin. Okay, we're going to go ahead and go to public comments. As noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read all the written public comments. We thank you for that. The committee coordinator or chair will attempt to call the members of the public in the order that they appear. To facilitate hearing as many members of the public as possible, I encourage you to not repeat points that were made by previous speakers, and to allow the committee the time needed to deliberate on the important topics that it will be discussing today. We will be limiting public comments to 2 minutes per person. Now, for those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom center of your screen. If you wish to make a public comment, please click on it. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. The coordinator will call members of the public in the order that they identify raised hands and will enable the microphone of the speakers. Devin, are there any public members that would like to make a comment?
Yes.
Okay, Devin, if you can go ahead.
Our first public comment will be from Peter.
Greetings. Can you hear me?
We can, thank you.
Thank you for taking my comment. My name's Peter Maduro. I'm a clinical psychologist and psychotherapist licensed in California. Also a licensed attorney in 3 states, New York, Massachusetts, California, and have thus taken 4 bar exams, not having passed the California one in the first attempt. As a therapist, I've worked clinically with more than one disabled patient who prepared for and requested testing accommodations, took the California bar exam with aspirations to earn entry into the legal profession. More than one of them initially failed because, in my opinion, of inadequacies in the testing accommodations, application, provision, and administration of them. Many of them fail for reasons that are not the responsibility of the regulations. However, in these instances, the failures, in my opinion, derive from some unfairness in the TA processes and provisions. My hope is that the rule revisions will be formulated so as to eliminate such unfairness by assuring a sufficiently even playing field between among the abled and disabled. More specifically, 4 thoughts, 2 weeks initial petition decision turnaround is needed instead of the 60+ days. I believe this is important enough to add additional staff if necessary. Applicants should get at least 30 days to appeal any denial or substitution of testing accommodations so long as they petition at least 2 months before the exam. Third, unless there's undue burden on the state bar, no accommodation request should be categorically not offered for individualized consideration or require attestation of exceptional need. Rather, what's paramount is that they assure a level playing field. And finally, applicants should have the right to a hearing on denied requests for TA if they first appeal, and second, their appeal can't be granted on the papers. That would be the same entitlement for a hearing extended to applicants who the state bar intends to deny on grounds of moral character findings. Why? Because the denial of requested testing accommodation implicates the same liberty interest to pursue a chosen profession. Thanks so much for taking my comments.
Our next public comment will be from Benjamin Cohn.
Thank you. I also oppose proceeding on the testing accommodation rules revision without making the further amendments that I and most other commenters have been seeking since before the latest proposal was circulated for public comment. I believe that a key flaw in the outlook of the working group's assessment has been that they seem to have focused their efforts on assessing what can be improved without making changes to a plethora of assumptions that staff have insisted are required to preserve the administrative feasibility of the bar exam in its current form. However, it is the feasibility of providing disabled applicants the requisite equal opportunity to the state bar's program of attorney admissions and seeking entry to the legal profession that is presumed as a precondition of continuing the particular bar exam method of assessing minimum competency. While I disagree with your premise that the changes that have been proposed by public commenters would destroy the administrative feasibility of doing the bar exam in its particular form, if that was credited, and the conclusion would be that federal law does not allow the bar exam to be used as the way to assess minimum competency in that form. But as I said, I believe that the premise is mistaken in that it can be made administratively feasible if it's more expensive per applicant to do. That can be reflected in a variety of fundraising options that I submitted in written comment. And you can also, if you present to the California legislature that this is the reason you need more funds, I think they would be more receptive than in not include it in the punishment for Girardi, as long as you listen to their feedback on the rules revision. Several of the legislators have agreed with the overwhelming public comments that have been received. And I urge you to defer to the legislators' comments to build goodwill and not have them potentially preempt you or hold up the licensee fees for 2025 or whatever other actions they may take, instead of deferring to the working groups, especially on the not bifurcating the 2 weeks thing to a future rules revision. Thank you.
Our next public comment is from Charlene Halshay.
Hi, can you hear me?
We can, thank you.
Hi, thank you. Yeah, Charlene Clay Chair. We've been doing this for about 2 years now. I really, really wish that the committee would take me up on my suggestion that you work with testing applicants that are disabled, either past, present, or future, because we have a lot of very unique knowledge on going through this process. I myself have experienced several times where my accommodations that I was seeking previously, who had been approved by the bar exam, were denied to ultimately get approved by having to go up the chain of command. So I absolutely oppose requiring applicants that are seeking double time or additional time, private room, semi-private room, to have to jump through hoops after they've already been approved by the California bar staff for testing accommodations. Once you've been approved, they should not expire. If you have permanent disabilities, they don't magically disappear. I'm 54 years old. I'm sorry, but my abilities are not going to improve with time. If you're talking about somebody under the age of 25, perhaps that might be true. That might be applicable. I understand that the majority of your test takers are in that age group, but there are many of us over the age of 40 that have permanent physical disabilities. We have lifelong learning disabilities, but we've overcome them by working harder, working twice as long, working twice as hard as the average applicant to get through law school. Do not punish us once we go to take the California bar exam by limiting our testing accommodations that you had already approved for us. We have other commitments like children, family, work. We can't take the exam consecutively every single time if we don't pass. Please do not require us to take additional steps, additional testing, additional medical documentation every 6 months. That is punitive. That's not fair. And I believe it violates the policy, the the spirit of the ADA law. It's only going to bring more litigation towards the California bar, which I know you want to avoid. Please read all of our comments if you haven't. For every one of us that is speaking here today or submitted comments, there are thousands of others that don't even know that you're doing this. I do not think that the colleges, the high schools, or the
Our next public comment is from Kendra Mueller.
Good morning. I am a California bar licensed attorney with disabilities. I work in the civil litigation sphere, and I am making comment on behalf of Disability Rights California. We have submitted written public comment, and we are the largest disability rights group and federally mandated to advocate for the disability community in California. We provided a list of feasible edits that can be made, and these edits are important enough to amend the current proposals. I agree with all the aforementioned comments and a few other items I would like to provide. A few text changes, which are not large changes in any way, shape, or form. Ensuring that 4.80A is modeled directly from California law. 4.8B, ensuring a competent third-party non-biased expert is housed there. 4.8C, to include law school high-stakes testing. And ensuring Rule 4.83A7 treats all accommodations in the same manner, and subsequently treating all disabled individuals in the same manner. Unless this occurs, there is a disparate treatment on some disabled individuals versus others, and this denies certain disabled individuals meaningful access even to apply and take the application process. Thank you very much.
Thank you. Our next public comment is from Max.
Hi. I'm speaking as a former student of the People's College of Law. I just finished my 1L year last year and passed the first year law students exam and was planning to start my second year there this fall. And as you guys know, basically the chaos there has prevented that from happening. I was asked to prepare some documentation and submit some emails or whatever written documents, but my feeling is I've already spent more time than I would have liked being yanked around by the People's College of Law and frankly by this committee. I think it's been clear for long enough that the People's College of Law is not capable of self-administration. From what I see in the current agenda, they have a new interim dean I wasn't even aware of since I've no longer been contacted because I refused to sign a disclosure that was inaccurate, but this all has to do with the previous administration, so who knows what the new administration is planning. It's very frustrating to me that the routes we have to taking the bar are so limited in the first place, with quite extraordinary requirements for apprenticeship programs. But unfortunately, the People's College of Law has become just a rubber stamp for people who want to try and self-study. I'm in favor of people being able to self-study for the bar exam, but I'm not in favor of an organization using the imprimatur of being an unaccredited law school to take advantage of people who would like to practice this profession, but who have been boxed out of other law school options. I chose the People's College of Law for personal reasons that I won't get into, but many of my classmates were formerly incarcerated persons or persons who didn't have access to the resources that would have allowed them to attend an otherwise accredited law school. So anyway, I know that you're currently waiting for an inspection that's going to continue next Friday, and you're not likely to maybe make it, but thank you.
Our next public comment is from Claudia Center.
Good morning. This is Claudia Center. I'm speaking on behalf of Disability Rights Education and Defense Fund and Disability Rights Advocates. We have concerns about the latest proposed rules that are before you. One of our problems is that the rules have new language that references the federal law definition regarding a comparison to most people in the general population. That's not the definition of disability under California law. And that concept from federal law has been used to exclude a high achieving people with disabilities from the testing accommodations they need. And it's also incomplete even under the federal definition of disability, and that's included in our letter. It's a downgrade in terms of the embrace of disability rights and the scope. We oppose the failure to automatically grant or defer to prior testing accommodations granted by law schools and colleges for timed high-stakes exams. We are very concerned that the proposed rules do not resolve or ensure prompt responses to accommodation requests or deal with the timeline issues that candidates are facing. We believe that the State Bar needs to replace or diversify the disability consultants that they have long used and who have built and contributed to the unlawful system of testing accommodations. And instead, the new rules actually impose a new seniority requirement for these consultants. And there's no plan to implement the kind of training, supervision, leadership, personnel changes that are needed to bring the testing accommodation program from the unlawful situation that it's been in for decades into a lawful testing accommodation program. To implement those new standards is going to require a culture change, and there's nothing in the proposal or that has been publicly stated that will ensure that. Thank you.
Thank you. We do not have any additional public comments.
Thank you so much, Devin. Thank you so much for the public comments. The CBE takes the public comments very seriously and will give it serious consideration. Moving on to agenda item D, agenda 1, section D, the chair's report. I just want to mention a couple things in brief. It's sad to hear that our former CBE member, Judge Herman, who was recently a CBE member earlier this year, has just passed away on September 6th. So at the conclusion of this meeting, I'd like to adjourn the meeting in his memory. Second is that the subcommittee assignments were sent out by Devin via email to all of our CBE members. So let Devin know if you have not received the subcommittee assignments. Third is that I'd like to thank our previous chair, Paul Kramer, for such a wonderful job leading the CBE last year. And also want to let everyone know that Alex Chan is our vice chair this year. So if there's any questions or concerns, let Alex or myself know. And then the next item is I'm really excited that we have 3 phenomenal new CBE members who bring vast experience and expertise. And so I'd like to recognize them. And if maybe you could just say a few words, I'll start with Justice Mesawala, and I apologize if I'm saying your name not correctly, Justice, but if you can just introduce yourself, Justice.
Good morning. My name is Shema Hakeem Mesiwala. I am a justice on the Court of Appeal, 3rd Appellate District here in Sacramento, California. I am a lifelong native of California, born and raised in the Bay Area. My background is I spent 6 years as a trial judge before becoming an associate justice on the Court of Appeal. Before that, I was an appellate attorney, and I started my career at the Federal Public Defenders in Sacramento, and I am honored to be a part of this committee. Thank you.
Thank you so much, Justice. Judge Reyna?
Hi, everybody. My name is Renee Reyna. I am a Superior Court judge in San Mateo County. I've been a judge here for about 2 years. Prior to that, I served here as a commissioner. I started my career as a criminal defense attorney. Then for the majority of my career, I was a research attorney at the San Mateo Superior Court, as well as the California Supreme Court. I'm excited to be here. I, at one point, did actually was a bar grader and did some testing. So I'm familiar with that, and I'm excited to be here. Thank you.
Thank you very much, Judge Reyna. Alan Yokelson?
Hi, everybody. My name's Alan Yokelson. I am very excited to be here. This is actually my third go around with the Committee of Bar Examiners. I last served in ending in 2016. So I missed a lot of the excitement that you all went through in 2020 and 2021. And I really commend staff and everybody getting through that period. I know how incredibly hard that was. My day job, I'm head deputy district attorney at the LA District Attorney's Office, currently with the Justice System Integrity Division. And I look forward to serving again. Thank you.
Thank you so much, Alan. This concludes agenda item under the remarks from the chair. We'll be moving to agenda item number 2, which is the consent agenda. It will be the technical report on the June 2023 first year law students examination. Tammy, can I turn it over to you?
Yes. The agenda item that was posted for everybody to review does provide you with the technical information regarding the June 2023 first year law students exam. If there are any questions.
Tammy, I can barely hear you. You sound like you're on top of Mount Fuji. Can you get closer to your mic?
Can I stay on top of Mount Fuji instead? That sounds a little bit more exciting. Do you guys hear me okay right now?
Ashley, what do you say? I say barely.
Could be better.
Okay. Let me see. I'm not sure what I can do to make this better. Is that any better if I'm moving closer to my computer?
Tons. 10 tons.
Okay. So the agenda that was posted for everybody to review provides the June 2023 technical report with regards to the grading of the examination. I think all of the details are in there that everybody needed to review. If anybody has any questions, let me know. If not, we are asking that this is received and filed.
I just wanted to let the CBA know that starting this year, the items that are on the consent calendar is voted on and is approved as an omnibus item, meaning that one vote for the entire calendar, unless a board member decides to pull something off the consent calendar. So this is something new, what we're doing this year compared to last year. So I wanted to see are there any questions that an individual board member has for Tammy that needs to be discussed? If not, then we'll ask to call for a motion.
Well, this is Robbie. Tammy, as usual, you put together an excellent summary. I'll vote to adopt and approve the report.
Thank you, Robbie. Was there a second?
It's one motion for both items on consent, Dr.
Okay. Oh, and also Audrey informed me too that in regards to the second item, which is the report on administrative updates regarding law schools, that also is on the same motion unless an individual board member would like to pull it up and discuss it.
That's fine. This is Robbie. I'll include that as well in my motion to approve.
And this was Bethany. I was trying to second Robbie's motion.
Thank you so much, Bethany, for the second. Thank you so much, Robbie, for the first. If that's the case, then Devin, can you do a roll call vote?
Yes. Dr. Bolton?
Yes.
Robert Brody?
Yes.
Alex Pan?
Yes.
Jim Efting?
Yes.
Kareem Gangora,
Yes.
Paul Kramer,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence,
Yes.
Esther Lynn, Justice Macy Walla,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Dr. Cow.
Yes.
With 15 yeses and 0 nos, the motion passes.
Thank you, Devin. We'll move to item number 3 under examinations, which is the subsection A, actions on revisions to the testing accommodations rules recommendation to adopt following return from public comment. Christina, did you want to kind of talk about this, and then maybe Robbie and I could chime in afterwards? Is that okay, Christina?
Yes, thank you, Dr. Cow. For the new members on the committee, I just wanted to give a brief history of where we are today. I also want to give my continued thanks to the working group, Judge Brody, Dr. Cow, who have provided guidance, and all of the commenters who have shared their experiences with our testing accommodations process. In late 2022, so just about a year ago, the State Bar hosted 2 testing accommodation forums to hear stakeholder feedback regarding the testing accommodations process. And the rules were revised to clarify and streamline the application and the review process based on the feedback from the stakeholders, the LSAT consent decree, and the DOJ guidelines. These rules have been circulated for 3 public comment periods. After returning from public comment after the first 2 periods, the committee recommended changes based on the feedback received. And each time the committee recommends revisions to the rules will be sent out for another public comment period. The most recent and 3rd public comment period just closed on October 7th. And the today's agenda includes the public comments received during that 3rd public comment period. The summary of where we are at this point is we have devised an automatic approval process based on other high stakes exams. So if you've taken the bar exam, the first year exam, the MPRE, the LSAT, the MCAT, all of those high stakes exams, and you're requesting no more than double time or a semi-private or reduced distraction room, staff has now have the power to automatically approve you, which really streamlines the process. It reduces the timeline that it takes for applicants to receive decisions. The committee has also eliminated what we had originally, which was a 5-year timeline. So one of the commenters talked about today that if the State Bar has already approved you for a high stakes exam, you shouldn't have to go through and get more medical documentation. We absolutely agree. We eliminated that 5-year timeline. So if you have already been granted accommodations by the State Bar, you are going to be given those accommodations for future State Bar exams as well. Although not part of the automatic approval process, these modified rules proposals do give considerable weight to past testing accommodations approved for college and law school. And I'll let Robbie and Dr. Cow talk about how we have really talked about law school approvals and whether to put them into the automatic approval process, or as it is now, just giving considerable weight to those. The timelines is also something that the committee has heard from public comment. The committee, after the first public comment period, had made a motion that after we move forward with these rules, if and when we do, within 2 bar exam cycles, we will bring the timelines back to the committee so that we can really see how the updated case management system, how the updated forms, the questions that we ask on the forms, how that really affects the staff and the consultant work, and give an actual timeline. At this point, we haven't used the updated system, the updated forms, We haven't clearly communicated that we're doing an automatic approval system to the applicant. So we'd like to update everything and then come back to the committee and give a revised timeline based on where we are at that time. The timelines that we have moved forward with is the appeal timeline. Originally in the rules, you as an applicant were given 10 days to request an appeal of a decision of a denial or a partial approval. We originally extended that to 14 days, from 10 days to 14 days. This most recent public comment period, we actually extended that to 30 days. So applicants that apply by the timely filing deadline or request review by the timely filing deadline will have 30 days in order to accumulate more documentation, go back to their qualified professional if they need to submit additional documentation. I think I've highlighted the biggest changes based on some of the commenter feedback. Dr. Cow or Judge Brody, would you like to expand on anything?
Well, Dr. Cow, let me jump in quickly. I don't really have much to add, and I thank you, Christina. You have been tireless in being responsive to comments that have come in, work, and CBE members. I have to say, I think we have landed at present on a great set of revisions that I know are going to greatly reduce the timelines for our applicants. You know, the number one goal here, as our very first speaker this morning said, is to be fair. We want to level the playing field. We want to make a procedure that is fair to all applicants. And I think what we've done by creating some automatic approvals, we are going to see a great reduction in the bottleneck. I'm so anxious to see how this is going to work out. I'm anticipating as many 25–30%, Christina, of our applications will now be streamlined and approved. And we've also extended the timelines, which so many of our public commenters and we at the bar have been anxious to see. And if you have a timely application, you are going to have 3 times the amount of time to appeal if you need to. And I think we're going to see a reduction in the number of appeals as well. With respect to law school accommodations, this has been, I don't want to say divisive, but certainly a number of public commenters have advocated for it. But what you won't see are comments from law schools advocating for it. I can only think of one law school, but the majority of the schools, and I have done my own call outs on this, law schools want the bar to offer that layer of review if there is a question. Remember, the state bar's rules provide for considerable weight, but you know, we can't speak to what every law school does, and what every law school does is different. When it's a high stakes exam like the SAT, the LSAT, we know the process. We know that it is the same across the board for all applicants. But I can't speak to each and every law school in this state, accredited, unaccredited. I can't, and neither can they. And law schools that I speak to, and I say, hey, should we just accept what the law schools have granted? They say, no. Robbie, please provide that extra checks and balances offered by the state bar to ensure fairness to all applicants. Again, we're giving considerable weight. That's not nothing. That means it is reviewed with an eye towards approving. And if there is a need for an independent review, then the applicant is going to get it. And to the commenters that say that it's the same old thing at the bar, I would have to disagree. We have a new consultant at the top in place to review, who is independent of the bar, who has been on board. Amy, I don't know how long, has it been a year? that we have been working with this professional to review accommodated application requests. And for those of you on the subcommittee with me, I think we've all been pretty pleased with the level of review, the ones that are granted and the ones that come to the CBE. So CBE members, old and new, I'm very pleased with these steps in the right direction. And I think we're going to see a better process for all applicants going forward. So I would encourage you to approve the modifications that have been made as of for today's meeting after 3 rounds of public comment. So thanks, everyone. And again, Christina, thank you for shepherding this through with us. Dr. Cow, what do you say? Am I all wet?
No, thank you so much, Robbie. I really wanted to echo the sentiments that Robbie had just discussed, that Christina has worked tirelessly, Robbie as well too, and that we really evaluated and examined the 3 sets of public comments. I'm not really going to go over the points that Robbie had mentioned, which I agree with wholeheartedly. I just do want to add that the state of California, we have 44 law schools, 16 ABAs, 14 accredited, 14 registered and unaccredited. The reason why I want to just bring that up is just a reminder for the public and our CBE members is that because of that, the rigors of each law school may not be the same on how they determine that. But otherwise, just like what Christina and Robbie had mentioned, this is really moving in a positive direction. And I'm very optimistic about where we're going. But I'd like to open it up to comments from our fellow CBE members. I see Paul Kramer, your hand is raised. Paul, can you go ahead and speak?
Sure. The substance of the review standards, I'm happy with and I support. But I have a kind of a procedural, some questions about aspects of the procedures. First of all, this would fully delegate the consideration of appeals to a subcommittee. And I'm also fine with that. But from what I understand from a private conversation with Christina, the plan is that when we have some appeals to consider on the day of our full CBE meeting, that we would combine a meeting of the subcommittee along with the CBE meeting. And I worry that that's going to be awkward. As you may recall, those of you who have been around a while, once we determined that Bagley-Keene applied to our meetings, and when in the old days, we had the practice of the subcommittees meeting before the full committee met and deciding things to recommend to the full committee. But, and when those meetings were in closed session, the members of the CBE who were not on the subcommittee had to leave the room. And we ultimately decided that that was just awkward, given that the full committee is going to have to consider it anyway after the subcommittee does. And so we quit having separate subcommittee meetings to discuss topics, especially those in closed session. So bottom line, I think this is going to, if we're going to combine a subcommittee meeting with the full CBE meeting, it's going to be awkward. I think the suggestion was that the subcommittee would meet for half an hour, say at 8:30 on a full committee day. And then they would be done, and then the full committee would conduct its meeting. But to the extent we're doing it in person, that means that as most of us are arriving for the full committee meeting, we can't even go in the room because the other people have occupied it and we're not allowed in there. And I suspect that's going to be, not considered to be optimal by many people, me included. So what I would suggest is that we retain our current practice, which is we delegate to the subcommittee for decisions that need to be made in between our regular CBE meetings. But then we have the full CBE consider appeals that come, that are ripe for decision on the day that the full CBE is meeting, or schedule the subcommittee meetings at a different time than the full CBE meeting, a different day, so that they don't overlap and get in each other's way. There'll be other technical issues such as keeping several Zoom meetings open. It's just it's unpleasant. And then my other question is for staff. We continue to hear objections to the effect that we've not properly implemented state and federal disability laws. And I wanted our council to weigh in as to whether they are satisfied that we have properly done so.
Sure, Paul, I can speak to that. The proposal that the CBE is considering today incorporates language from Title II of the ADA. Title II applies to public entities offering testing accommodations. As compared to the general population, language that we've been talking about comes directly from a regulation that's implementing Title II of the ADA. And our position is that Title II of the ADA is the governing law in terms of considering testing accommodations, because there's no parallel law in California regarding testing accommodations. There is the Unruh Act. The Unruh Act generally can provide for protections for testing accommodations, but in order to show that the Unruh Act has been implicated or violated, you'd first have to show that the ADA had been implicated or violated. So the ADA definition is the definition that we go with here.
Thanks.
Hey, this is Robbie. If I could just respond, and thank you, Paul. I know you're not on the subcommittee, but you have put your nose to the grindstone for all of this, and I don't think we need to approving this proposal involves addressing how we would have these meetings. I don't think that's part of it, but I suppose I want to say that I think meeting before our regular meeting is a good idea, and we'll work the logistics out, but it allows every applicant who has filed an appeal to get the benefit of the CBE review. And as you know, we do it. We're not kidding around. When we have those meetings, members that have been assigned certain candidates, they are ready to go. And sometimes it is hundreds of pages. And I think that those on that subcommittee will be able to do it. Remember, we're talking about the very, very few, I think I'm correct, Christina, that could not have been heard between meetings. So I don't expect this is going to be more than a very small number and a very short meeting. So I know it sounds a little clunky, Paul, with everything being on, online and Zoom, but I think we're going to be able to do it. Christina, am I right? We're talking about a relatively small, that's what I would anticipate.
Yeah, obviously, the July bar exam is one of our larger bar exams, and you would probably get most at that point, but yes, absolutely.
Thank you, Paul. Vince, I think I saw your hand raised next.
Yeah, thank you, Chair. I just wanted to commend the subcommittee on the very detailed work and the report you came up with. I had the opportunity to sit in on a couple of the sessions of the public hearings last year, and I see that a lot of the comments that were made those changes are reflected in your report, so I'm happy about that. I think what I wanted to say was, Robbie, I appreciate what your comments on what the law schools think about, because that's always, I think, for me anyway, been a question as to if the law school says, if the applicant is saying, well, I had this accommodation in law school, why can't it just carry over? I think you have a good explanation for that. So I appreciate that you actually took the time to check with individual law schools, especially in these high stakes testing. It's a different situation than just carrying an accommodation over. So I appreciate that. Thank you.
Thank you, Vince. Alex, I saw your hand raised.
Thank you, Chair. Mr. Brody, I really appreciate your leadership on this important task. I just can't imagine another person who could take this on with more tenacity than someone like you. If I may, I want to propose sort of a solution for your consideration, and this is in relation to sort of the general concern surrounding the different protocols or review standards promulgated at different law schools for testing accommodations. The potential solution for your and the working group's consideration is what I call an early approval process. What this entails is that law school students would be allowed to submit their request for disability review through the state bar early on while they're still in law schools. And when the state bar grants those requests, the law schools are encouraged to adopt the same throughout those students' 3 or 4 year law school study. And so again, this is what I would call an early approval process. Instead of just waiting for these applicants to start that process at the time when they apply to take the bar exam, we can punt it early on so that at the beginning of their law school cycle, we start that process. Now, on our end, for those applicants with permanent disabilities, that should be a fairly straightforward review, right? The advantage is pretty obvious. When those students apply to take the bar, again, on our end, we'll be in a much better position to automatically grant those accommodations requests. This saves time and resources for us and for everyone. And for law schools, they also will benefit, I think, from this early approval process because it alleviates the burden for them to review these applications or hire outside consultants to do the same. But obviously that also help us level the playing field and in terms of the different protocols that are just surrounding the concerns that we have. Again, there are logistics to be hashed out, including financial considerations, who's paying for what. But in principle, I think an early process would benefit all stakeholders. So I would ask you, Mr. Brody, and the working group to sort of consider a long-term solution to sort of further help out these applicants in the long run.
If I may, Alex, applicants can actually submit the testing accommodations application as soon as they've registered with the state bar as an applicant. So the first part of that process is essentially already in place. It would just be the law school portion.
Thank you. This is very helpful. Then perhaps we need to maybe have a sit down with all the law schools to see if this is something that can be expanded. Because I do think the applicants, obviously it is a very stressful time, not just law schools, but obviously the bar exam period. If they can, get that process started early on so they don't have to worry about it for the rest of their law school cycle and also the bar exam, I think it would help all parties out tremendously.
Hey, Alex, thanks very much for your comments, both to me and Dr. Cal, but I know you have been an active participant in this, and I've read your comments and I really appreciate you going out. But to Alex's issue, I wonder, Christina, when we talk about great deference that is afforded to those applicants who have received approved accommodations in law school, maybe can you share a little bit more? What exactly does that mean when we talk about deference is given? So, and again, Alex and CBE members, there are applicants who have received no accommodations prior to sitting for the bar exam. So we're looking now at the category that Alex has so correctly highlighted, where accommodations have already been granted. But Christina, in practice, how does that play out? That deference.
Yeah, so really, it's just that, it's deference is given. The consultants, if the file proceeds to a consultant, meaning that it's not part of the automatic approval process, understand that the applicants that have received accommodations during the law school these are what they're used to. They're used to either receiving extra time or a note taker and things like that. So essentially it just means just that, is that the consultant, if they're looking at the file, takes into consideration and deference to what the law school has given the applicant on timed exams, not necessarily regular classes, but on timed exams.
Okay. And Alex, again, I'm so appreciative of you and all the members that have, weighed in on this. Our number of requests for accommodations grows with each bar. And our summer bar, we're looking at 10% of our applicants requesting accommodations of some sort for the summer bar. That is almost 1,000 applicants. So it's not nothing. And we're trying to be so careful. It's a work in progress. And Mr. Chan, what I would say to you, I would like to see these, what I hope are streamlined processes in effect for the next bar. And let's see if bottlenecks are removed. And if we need to go further, then maybe we can talk about sitting down with law schools and figuring out how we can further cement the process for those accommodated applicants. Thanks, Tom.
Thank you. Thank you, Mr. Brody. And also, I'm also currently reviewing the timelines, and maybe at the next meeting, I may have some more suggestions that I would like to propose to you, if that's okay.
Yes, can't wait.
Thank you, Mr. Brody.
Thank you very much, Alex, for your wonderful insight and about your thoughts. And thank you very much, Vince, as well, too. Are there any other comments from our CBE members that want to speak or have any other questions about what the working group has been crafting in response to the public comments?
I would like to make the motion to approve the motion from the bar with respect to accommodations. Oh, here it is on the screen.
Robbie, do you want to read that motion?
Okay.
Is that okay?
Well, with respect to actions on revisions to the testing accommodations rules, the recommendation is to adopt following return from public comment. We move that the committee recommend that the Board of Trustees adopt the rule revisions set forth in attachment C and request approval of the rules change by the Supreme Court. So of course, what that means is that if we approve the changes, that will go to our Board of Trustees for their review.
Thank you very much, Robbie. Is there a second for this motion?
I'll second that. Alex Lawrence.
Thank you, Alex. For Alex Lawrence, thank you very much for seconding that motion. If we have two members making the motion then already, let's go ahead, Devin, and let's call for the vote.
Mr. Chair, can I ask a clarifying question?
Yes, sir.
By voting on this motion, by no means we're saying we're not going to be revising the testing and accommodation rules any further in the future. This is just one step of the process, correct? Meaning we will still be reviewing and revising the testing and accommodation rules going forward. Is that correct?
Yes, that is correct, sir.
Yeah, and let me just say one more thing. I'm so glad, Alex, you brought that up, because this is an ongoing process. And I think it was either you or Paul that highlighted that we are going to be looking at statutory changes to advance the deadlines for applying, which ultimately will provide even more time for all applicants. So plenty of work ahead in the coming year. This is a step that I think is going to make I'm anxious to see if I'm right that it's going to make a big difference, but we are still looking, especially at the timelines, and providing more time to all students applying to sit for the bar exam.
Robbie, I know I suggested that in the past, but I'm not sure that that's on the work plan. when we get to the work plan later today, maybe we should think about checking for that and putting it on there if it is not on there.
I thought it was on there, but thank you, Paul. Yeah, when we get to that point, because I know Donna and I have talked about this, so it's definitely on the horizon for the bar. Okay. Oh, I think Kareem has is that your hand or is that part of that palm tree?
That's my hand, Robbie.
Oh, right on.
Awesome. May I be recognized, Dr. Cal?
Yes, Kareem. Sorry, I didn't see your hand up. I apologize, Kareem.
No worries. Totally understand. And I just wanted to thank the individuals that had made the comment earlier in the speech. I think Mr. Brody has captured it correctly, and Mr. Chan, that this is an ongoing process. For me, I take this issue very personal because of my personal life and raising a child with disabilities. And so I think what we're hearing from the staff and from the committee is that we're hearing you, we're listening, we're trying our best to make progress. And so please continue engaging with us, because I think ultimately our goal is to find how we could better administrate this program. And so I just wanted to give a kudos to the team and Mr. Brody's leadership. There's no one else I could trust more than to do justice on something like this. And so I know it's a great task ahead of us, but to the commenters and the organizations that joined today, thank you so much for your work and your comments, and please continue holding us accountable and giving us your feedback. It's only going to improve the process and move us forward. So yes, those are my comments.
Thank you very much, Kareem.
Thank you.
Are there any other members of the CBE that would like to discuss this? If I missed your hand in any way, I apologize. I just want to make sure that everyone's recognized. All right. Looks like there's no other comments from our CBE. So then we will go ahead and proceed with the roll call vote then, Devin.
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora?
Yes.
Paul Kramer?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence?
Yes.
Esther Lynn? Judge Macy Walla?
Yes.
Bethany Peak?
Sorry, yes.
Thank you. Ashley Silva Guzman?
Yes.
Judge Reyna?
Yes.
Vince Reyes?
Yes.
Alan Yokelson?
Yes.
Dr. Cow?
Yes.
With 15 yeses and 0 nos, the motion passes.
Great. Thank you, Devin. The next item is action on modifying the first-year law students examination to eliminate essay questions resulting in all multiple choice exam. That is a special session set at 11 a.m. So we will wait for that time to be able to start that session. So we are going to continue to move forward to agenda item number 4, which is operations and management. The subsection A has been withdrawn. So we will go ahead and move to subsection B, which is the action on eligibility rules, recommendations to circulate revised rules for public comment, recommendations to repeal duplicative policy on calculating 1 year of credit, and recommendations to adopt legislative proposals. So may I turn this over to Donna?
You can turn over to me.
Okay, Audrey.
That's hi
Thank you.
everyone. I'm here. I'm here at the office, so if you hadn't seen me yet. So thank you for reading that very long title. I'm going to share a slideshow, and I've shortened the title slightly, but we are going to cover all these parts today. So just before I pass it over to Donna for the first part, I just wanted to recap that we've actually first brought kind of a staff overview to the committee last December. Then we got volunteers for a working group. David Torres, who is now not on the committee, and Ashley Silva Guzman were on the working group. We came back with a proposal that has a lot of the same elements in it that we'll talk about today in April. And then after that, Paul Kramer joined the working group. We've made some more revisions, and like all the rule revisions we've been bringing to the CBE since last year, we're looking about clarifying our rules, making them consistent across rules and statute, removing unnecessary barriers, and kind of going back in CBE history, looking at old CBE minutes and motions in the past to make sure that things that might have occurred, and in this item, if you've read through it all, occurred maybe 10 or 20 years ago that haven't been missed, that were good ideas that didn't get moved forward in the appropriate way back then. So that's just sort of a recap. And we go to slideshow, and we'll start off with Rule 4.15.
Wonderful. Thanks, Audrey. So again, I think Audrey may have said this, but we're looking at sort of broadly the eligibility provisions, rules, statutes, etc. And we're talking about eligibility to be certified to the Supreme Court, eligibility to sit for the bar exam, and eligibility to sit for the first year law students exam. So really all of those things rolled in together. Obviously the rule proposal, we're not going to touch on everything that is in the rule proposal, but we wanted to highlight some of the key areas where the working group had the most significant discussions or were suggesting the most significant changes. So first on Rule 4.15, this is the rule that identifies what an applicant needs to have done in order to be certified to the Supreme Court. And one of the things that's listed in this rule is that they need to not be on the certified list of those who have delinquent child or family support obligations. This is a list that is provided that's created by the Department of Child Support Services, and there is a statute, Family Code 17520, which identifies that as a general rule, people who are licensed either should be suspended or should, if they're not yet licensed, should not be able to get a license, a business or occupational license, if they have a delinquency. And they define sort of what that level of delinquency is for child or family support. What's interesting is our rule doesn't align directly with statute. Our rule says if somebody has this, it appears on this certified list of delinquent obligors, then they're not eligible to be submitted to the court for certification. And it is a very long and complex statute, but if you read it closely, what the statute says is with regard to those who are already licensed, as well as those who would be first getting their initial license, the requirement is that you issue a 150-day temporary license if they do in fact appear on that certified list of delinquent support obligors. You're supposed to issue a 150-day temporary license to give them the opportunity to resolve the child support or family support arrearage. If they don't do it within the 150 days, then they are suspended. So the working group spent a lot of time talking through this because this is a policy call, and there may be, I would fully expect that there are going to be some people on either side of this issue, and the working group really struggled with it. And ultimately, what the working group decided was that we should continue our current practice, which is that you do not get your initial license, i.e. you don't get certified to the Supreme Court if you have a child support or family support delinquency. This would require a statutory change, And then we also are proposing a rule change just to clarify the language because it's a little clunky and doesn't quite, it isn't sort of perfect in how it defines not being eligible for certification. This, just to give you a little background. So in my prior life, I worked for the State Department of Child Support Services, and I actually also worked in the legislation that created that department. So I have some familiarity with this family code section and the purposes behind it. It started actually with a driver's license suspension, and that I believe is 1992, 1994-ish. There was a statute that said your driver's license would be suspended for failure to meet a child support obligation. The debate at the time was, okay, but if I don't have my driver's license, I can't get to work. I can't make the money to pay off the obligation. So as a result of those debates and discussions, there is this 150-day temporary license that gets issued so that it doesn't stand in the way, this not having a driver's license doesn't stand in the way of being able to earn money and get to a place of employment. The statute then extended beyond driver's licenses to business and professional and occupational licenses. And again, they built in this 150-day temporary license so that someone, and the State Bar does this with regard to those who are current licensees. If you are an attorney and you have an active license, we get the monthly list of delinquent obligors from the Department of Child Support Services. We get a match and we learn that your name is on that list of delinquent obligors. Then we send you a notice and we say, you're on this list. You have 150 days to clear this up. Otherwise your license is going to be suspended. So that's sort of kind of a reverse version of creating a temporary license, but that's what we do. We give them 150 days to resolve it. On the admission side, we are not aware that we've ever done it that way. We just say you can't get a license. And the policy debate here really has been, should we be treating those who are first going to get a license the same way that we treat those who currently have a license? And this is one of those things where we can't quite put our arms totally around it, but it feels a little different. That you are opening, that if you were giving someone a license in the first instance, right, who hadn't been licensed before, potentially going to put out a shingle, who are going to sign up clients, who are going to have access to client funds, and then in 150 days could be suspended. And so it felt different to the working group, and the working group felt like, no, we'd like to continue this the approach that we've currently had, which is you don't get certified to the Supreme Court if you have a child support or family support delinquency that puts you on this certified list. Over the past 3 years, there has probably been one individual, maybe a couple more, but probably one person who the sole reason for not certifying them to the Supreme Court was this support obligation. Anyone else who was on this certified list also hadn't passed moral character or didn't have the MPRE. There were other reasons that would have prevented them from being certified at all. So it's a very small number for whom this is the only issue that keeps them from going forward. But we did want to sort of put this debate out there for you because it's a policy call that the CDE gets to struggle with and decide, should we continue the current practice, which is consistent with statute, but not our current rule. So we need to change our current rule if we're not going to do that, or request a change in statute. As you see, if you noted this part in the analysis, I did have a preliminary conversation with staff in one house of the legislature, not both houses, but one house. I also had a preliminary conversation with a Supreme Court liaison, and they also seem to say, yeah, I can't quite put my finger around it, but the public protection issue seems more prevalent if we're talking about somebody who is yet to be admitted. And so the individuals that I talked to believe that there was a good policy reason behind seeking the statutory change and keeping our process the way it was. So that's the proposal with regard to the change, the biggest part of the change in Rule 4.15.
Donna, can I ask a question, Michael?
Yes.
So Donna, is the failure to meet these obligations, is that a moral character aspect or not? Tara may be able to help with that as well.
Yeah, Tara's the best person to answer that question.
It's something we consider, Paul, but sometimes it can also occur after they've already been granted a positive determination. They should technically tell us that, but it can also arise afterwards during that 3-year period of the positive determination.
Right. But then another question, I guess, is failing to pay that, could that be, assuming they are a member of the bar, is that a disciplinary issue ever?
I don't believe so.
Okay, so it's kind of more like a,
It's an administrative, you get an administrative
Right.
suspension, not disciplinary.
yeah, so okay. Yeah. So if we adopted the proposed language, I understand the argument now. I was concerned that the staff report didn't, just use the bar's catch-all justification of public protection without explaining, exactly how the public was being protected. But I now see that the risk of having somebody start to practice law, sign up clients, and get going, and then have to abandon those clients when they get suspended. That would be an unfortunate event that we might want to prevent. So I'm starting to see the public protection argument. I just wish it had been fleshed out earlier. But if we were to adopt this language, it is not consistent with the current law. And it's only maybe at the end of next year, if we're lucky, that the law would be changed to authorize us to be this insistent that they not have an obligation. So procedurally, I'm a little uncomfortable with adopting a rule that's inconsistent with the law. We finally identified that we had this problem, and to correct it in a way where we hope the legislature will agree doesn't seem quite right to me. But I think I'm now supportive of the idea that we shouldn't let them get started if they have this problem.
Michael, can I make a comment?
Absolutely, Ellen.
I'm just responding what Paul, I think, Paul, you put your finger on it, though. It can be a moral character issue if it is a willful failure to pay, as opposed to simply circumstances. And I think that alone would require an additional investigation into that issue, and that alone would justify preventing certification to the Supreme Court, even if they have already received a positive determination. But I think it should go back for a determination of whether or not this is a willful failure or not. And that alone would take care of that issue, at least until hopefully it can get legislatively addressed.
But isn't the legislature's statement that we should let them try to earn the money, in effect, negating our moral character concerns? In other words, the legislature should be deciding whether we can do this, not us.
It's not a perfect solution, but I do think there's a significant moral character issue here. If there is a willful failure, and we won't know that until it's referred back and there's subsequent investigation.
And so maybe moral character should be looking at these lists and comparing them to their outstanding positive evaluations then.
Do they do that now, Tara?
No, so the applicants still have a duty to update us within 30 days of any changes. So they should be telling us. We also send out halfway through the positive determination that what we call the 18-month update letter, asking if there's any circumstances that are changed. But what we could do is have the system automatically notify us if somebody with a positive determinant has received a SLIMS hold, because we have that right now with the fingerprint. So I think that's something we could build into the system.
Yeah, and that would be good for applicants too, because then they would get a heads up from us when we said, hey, your moral character is suspended, that they have a problem, although presumably they know about it. But maybe they don't think that it's, it's a capital P problem at that point.
It is highlighted in many places on our website that having a delinquent child or family support obligation is a barrier to being certified to the Supreme Court. But I think sort of the combination of what Paul and Alan said and sort of Tara's administrative way to deal with that, getting the notification of the SLIMS hold is what Tara referred to that as, with a state license match system, getting that referral, then they would know at that time and be able to look into the moral character issue, because if there was a delinquency while they were reviewing the person's moral character, that is something they'd be looking at. So it does make sense for them to look at it before the person gets certified ultimately.
It sort of trusts the applicants to tell us what they're up to, but also verify when we have the means.
Bethany, did you have your hand up?
I did, yeah. And Donna, I apologize because I'm trying to pay attention to you and read. And so I'm just trying to make sure I understand. So our current policy is that we, right now, these people that are on this list, they do not get their names submitted to the state bar or to the court. And so the proposal would be to continue that policy and not provide them the 150 days that the other statute says that they should be permitted.
Yeah, the only clarification I would make to what you said, Bethany, is that it's not current policy, it's actually current rule. The rules currently say you don't submit them to the Supreme Court. And yes, our proposal is to continue that. And therefore, now that we have identified this inconsistency, to seek to change the statute to bring us to make sure that there is alignment between the two.
Okay. All right. Thank you for that. Then this is just a comment then, outside of the context of the state bar, I am generally anti these policies of depriving people that are on these child support lists from the opportunity to make money in order to satisfy the past obligation that they have. I understand the concerns about letting people starting to practice, and then it's like, oh, now, 6 months or whatever, they have to withdraw as counsel. That is concerning, but in my opinion, I don't think that's a substantial public protection justification to continue to stop these people from being able to satisfy their obligation. And so, yeah, I just wanted to add my comment to the discussion, but thank you for the clarification, Donna.
And I do want to sort of an interesting development that just happened very recently is that the Supreme Court has now, we had submitted a rule to the Supreme Court about this process of providing the temporary license to active licensees. And in approving that rule, they made a modification, and as part of that modification, they required anybody who's suspended for this reason, for not being from having the child or family support delinquency, that person needs to file what's called a 920 declaration, which means that they've got to give notice to their clients, they've got to give notice to the courts that they have been suspended. They have to give notice to opposing counsel, and then they have to submit a compliance declaration to the state bar saying, yes, I did comply with this. So that's something that is a brand new development that may give those who feel the same way as Bethany enough of a comfort level that, yeah, there is at least going to be some notice to clients, so they'll know. that this happened, and it certainly wouldn't alleviate sort of them necessarily being left hanging, or is there a incentive because of a pending suspension to violate the trust account rules and to take funds from clients again, right? This is something that incentive, to the extent it exists, would be true for active licensees as opposed to those who are about to become licensed. But to the working group, it just felt a little different. Like there just was a difference, and it felt like at the front end, getting licensed, knowing that you're going to have this license for a short period of time, unless you resolve this, would create a greater risk to the public than existing licensed attorneys getting that same notice.
So to follow through, they would be admitted, but immediately need to file this disclosure to potential clients.
Yeah, I would need to look up the exact timing of the disclosure. The timing of the disclosure may be once they get suspended. So it would be after 150 days or so.
It would be better if it was up front, that would alleviate the issue of them taking on clients.
Yeah, but I'm 99% positive it is upon suspension and not in the 150 days prior.
And Donna, isn't it? I thought a couple of minutes ago the Supreme Court did something similar for licensed attorneys too. I think this was obviously in light of the recent events surrounding Girardi, where all the attorneys who are suspended have to now notify all the clients, the courts about this, and opposing counsel as well about the suspension. So it sounds like it's just an extension of that.
Well, that is normally the case. That is a requirement for disciplinary suspensions. In this case, it was added for this kind of administrative suspension.
And what about those who are suspended for failure to pay their dues? Do they have to do the same thing? They certainly should.
I don't believe so. I think those who are suspended for failure to pay dues and potentially failure to meet the MCLE requirements are not currently required to file that declaration. But I'm sure with the addition of this new requirement in Rule of Court 9.22, the court is looking at other administrative suspensions and doing the analysis of when they think it's appropriate for that notification.
Robbie, you have your hand up, Robbie? Oh, Robbie, you're on
Yeah,
mute.
I'm sorry. You know what? I wanted to echo something that Alan said, and wholeheartedly with Bethany, that we can't overlook the fact that there are circumstances that might prevent this obligation from being satisfied that is outside the realm of a bad moral character finding. I see this in the court where I sit fairly frequently, and of course, I can't think of anything worse than an outstanding child support obligation, the stereotypical deadbeat dad. I mean, gosh, that I can't think of anything more awful, but I will tell you, there are circumstances where good faith parents cannot meet that obligation, and it is not because of an refusal to pay or an unwillingness to pay. Sometimes there is a good faith inability to pay, and the obligation is there, and the DA is enforcing it. But I would not put it in a bad faith category that would preclude someone from working to meet that obligation in the future. Again, just as Alan said and Bethany said, there are circumstances, and we would have a duty to inquire before making, a very bald blanket assessment of unfit based on that filing that we become aware of. I just feel like I need to add that to the mix.
Well, but this system doesn't really allow us to, if we turn it into a moral character issue, then we could make that examination. But if this literally says if they're on the list, which is created by somebody else, we have no choice. So Donna, in the creation of the list, do they look out for cases such as Robbie is describing?
No,
I don't think so.
no,
Yeah.
no. And the alternative, right, just so everyone's got it in front of them, the alternative, instead of modifying the language in Rule 4.15 as we had proposed, is simply to strike out the existing language, and that is no longer a criteria for certification to the Supreme Court, right? That's the alternative way to approach that. And so I just wanted to, right, this really is one, Paul, as you and I communicated, where it's a policy call that I can completely see going either way, and I wanted to make sure the committee is aware of how that would be effectuated.
Do we have the right to issue a license, or does 17.520 say we cannot?
17.520 requires the issuance, specifically says if the sole reason that the person would be denied a license is because of the appearance on the list, then they are to be given the temporary 150-day license. It would be, it's slightly more difficult to effectuate than it is with existing licensees, because we can say, okay, as you're going to be submitted for a suspension, on X date, right? Versus if we certify somebody to the Supreme Court, then we simply have to track once they get sworn in. If they're still on the list, then the 150 days starts from there. So we will figure out administratively how to do it if that's the committee's wish.
Are there any other comments or questions from Paul and Ashley, because you were on the working group for this?
Well, Donna has just talked about one of the aspects, so I think there are probably more aspects of this package to speak to. So Donna, you don't think that 17.520 is applicable to the state bar unless, I think it may be, because it defines a license, including membership in the state bar.
Yeah, no, 17.520 absolutely is applicable to the state bar. What I'm saying is, with regard to initial licenses, we have not been following it.
No, but what I'm saying is, I don't know that we have the ability to just say we're not going to make that requirement and let people come in if they're on the list. I think the law may be that anybody issuing a license, and certainly us, has to deny it if they're on the list.
But we have to issue the 150-day temporary license.
Right, but we can't just let them through without checking for that. So I mean, some people might be happy with the idea that we just get out of the business. I think Bethany would, of holding licenses hostage for child support obligations, but I'm not sure that we can.
And like I said, it is exceedingly rare that is the only issue that prevents certification. It is often in combination with not having not having yet a positive moral character, or not having passed the MPRE. Exceedingly rare that it is the only thing standing in the way. But it has happened, and we certainly want to make sure that the statute and the rule ultimately are aligned.
Yeah, okay, so we have to do something. And I think we do have to amend the reference to be more specific to the list, because as it's currently written, it suggests that if anybody came and told us that they had an outstanding obligation, we would have to take that as as grounds to not allow them to become a member. And using the system that where another agency is compiling these lists, I think is it takes the burden off of us to try to search for the information, but also means that there's a better system for verifying it, and making sure somebody's not been on inappropriately labeled a child support, well, a bad dad is terms Robbie would use.
I'd like to recognize Judge Rayner.
Yeah, thanks. I just had a question concerning what the working group looked at. It seems, first of all, that Donna, you indicated that there are very few people that this is applied to. That you said one or something, maybe, that had been denied, I think. Is that right?
Yeah, we're aware of one in the past 3 years where this was the only issue. There may have been more who had a child support or family support delinquency, but they also had another thing which in and of itself would have prevented certification to the Supreme Court.
Right. I'm just also wondering if there was any looking at by the working group, arrears on child support payments can be, a monthly payment of $400, or it could be arrears and, $50,000, $100,000. And I don't know if there's a way to parse that out, but to look at if the working group talked about that in any way in terms of, what Judge Brody had indicated, is this someone with unique circumstances, or if it, is the typical deadbeat dad who's never going to pay this off, or, that leads into other moral character issues or something, perhaps. I'm just wondering if that came up and there can be a structure to look at it that way.
So the working group did not parse it that way, and largely because there is a state agency that is responsible for collecting all of this information, creating this list, and giving it out to the Department of Consumer Affairs and us. And so the Department of Consumer Affairs is engaging in the same process with somebody who is applying for or licensed as a barber or cosmetologist. The medical board is getting this information for people who are licensed as doctors. And so I think it would be I would be very concerned about us going in, looking at the debt, doing an analysis of sort of the level of the debt, or whether there is a justification for non-payment of the debt. I think we should either go with the requirements of the statute, or continue with our current practice based on rule, which is if you're on the list, you don't get submitted to the Supreme Court.
Okay, thanks. Just wondering if that was considered at all.
Yeah.
Any other comments? Yeah.
It's still, Donna's still the next slide. Yeah.
Okay.
Yeah. So I would like to say that was the most in-depth that we're going to go, and that everything else will be easier, but we'll see. Next, we wanted to highlight for you the changes to Rule 4.17. As the continuing members of the CBE will recall, the CBE made a recommendation to eliminate the 5-year expiration period on a passing bar exam score. So under the current rules, you have to be certified to the Supreme Court and get sworn in within 5 years after passing the bar exam. It's technically after the date of the bar exam that you passed. And so the committee there is a rule that gave the committee the authority to extend the 5 years, but it was the way the rule was drafted and the way the rule was applied, it was incredibly difficult to demonstrate to get that extension to the 5-year limit. And so we proposed a rule to the Supreme Court that would eliminate the 5-year limitation, analogizing this to somebody who passed the bar, got sworn in, was inactive for 6 years, 7 years, 10 years, and then became active. There is no requirement for them to take another bar exam, to do anything else to demonstrate their minimum competence. How are they different? No requirement for them to take MCLE in the interim. How are they different, the committee questioned, than somebody who took and passed the bar exam but didn't get sworn in, but everything met all the other requirements. So the committee proposed eliminating that 5-year limitation. The Supreme Court denied it. They didn't feel that the committee made a strong enough case for the elimination. So we took another look at 4.17 as part of these eligibility rules and said, okay, well, the Supreme Court didn't feel compelled to eliminate the 5-year limitation on the passing bar exam score. So let's give some greater guidance to applicants and to the committee and make it a little bit easier to qualify for an extension of that 5-year limitation. And so what we provided in the rule was authorizing the committee to extend the 5-year limit upon a showing by preponderance of the evidence that the applicant diligently attempted to complete all requirements for admission and take the attorney's oath before expiration of the 5-year period. And this is something that we spent a lot of time talking with Paul about, in particular in his role on the working group, giving some clear examples of what is or is not making diligent attempts to complete all requirements for admissions, what is objectively reasonable, what's not objectively reasonable. And so there are examples. And so just for example, somebody with an extensive criminal history, if the 5 they pass the bar, they haven't submitted their moral character application yet, year 1 passes, year 2 passes, year 3 passes, they're in year 4, it's 180 days before the 5-year time limit hits. And so they say, okay, I'm going to submit my moral character application now, because on the State Bar's website, it says that it takes a minimum of 180 days. So I'm going to submit it now with 6 months left. I have an extensive criminal history. That's not objectively reasonable to think that the State Bar is going to process my moral character application in the same time period they're saying they're going to process everybody's moral character application. So we put a few examples, not exclusive, but a few examples here of what would or would not be objectively, diligently attempting to complete all the requirements for admission in a way that's objectively reasonable. And so that's what's in this rule.
Michael, should I make my
Yes,
comments
Paul.
now? Okay.
Yes, Paul.
So the draft started out just saying objectively reasonable without defining that. And my objections to the current rule are that it's so vague that you really can't figure out what our standard is. And I didn't see objectively reasonable as being any less vague. But with the addition of the examples, I'm actually happy with this. I don't see this the same way Donna does, as making it easier for people to get extensions beyond the 5 years. What I see this as saying is that you need to make up your mind whether you want to be a member of the California Bar, and you need to start the process within a time where it is, likely, unless there's some weird complication out of your control, such as, staff taking longer than they normally would to process the moral character application. But for instance, it makes it clear that if you wait to take the MPRE at the last giving of that test prior to the expiration of the 5-year period, and it turns out you didn't pass the MPRE, well, that's your fault. You should get things going. So I don't see this as really letting people dilly-dally. I mean, we've had people come in and say, I moved out of state and wasn't sure I wanted to be a California lawyer, but in the last few months I decided, yeah, I really want that. Probably because there was something that was going away and they didn't like that, but that's not reasonable. So I don't think this is going to involve, I don't see this as extending the time limits. I see it as being clear to applicants what they have to do and when they have to do it by. And to the extent there's a delay, we've heard during COVID that sometimes they couldn't get a certificate of a particular type from say another state's bar because of the offices weren't open or whatever. I'm not sure where I am on that, but if somebody only applied for that, say in the weeks before their 5 years was up, I would say that's not reasonable. They should have done things early. So I first of all, I like this and I recommend it, but I don't see it as, I think the staff report suggested, as achieving most of what we were trying to achieve by eliminating the requirement. I think it's going to create very narrow exceptions, but more importantly, it's going to tell people to get off their butts and if they're serious, do what they have to do within a reasonable time ahead of the deadline's expiration.
All right, Alex. Go ahead, Alex.
Thanks, Bob. This is very helpful, your comments. One thing I'm just looking at the proposed changes. I know we have the word diligent in the language, but, for the last 2 years, we have seen applicants where, they may be just sitting on the rights for the first 3 years, and then they started, putting their applications together for the last 2. And so there's always a question about how to define diligence. At what point do you consider diligence to begin? And so I think that has always been sort of a challenging issue for the entire CPE, because again, without sort of a time frame or point of reference as far as how you measure diligence, it's going to be, I certainly get a sense that the committee will still be facing issues like that. So would it be possible perhaps to potentially consider the addition of a word like continuous, right? Continuously diligent, or continuously and diligently, putting together your application or something like this, just so that I think it gives us a clear cut and a probably objective basis to measure, whether the applicant is being diligent.
So I'll take that, Alex. And this will explain sort of why Paul and I probably see this rule differently. Under the rule as currently written, the committee takes a holistic approach to the 5 years, right? So the committee says you've had 5 years to get sworn in, or to complete everything, moral character, for example, or MPRE, and then get sworn in. And you have somebody who comes to you who passed the bar exam, was taking a job in Maryland, didn't need the California licensure for that, was moving with their family, didn't want to spend the money on the moral character exam or the licensing fees in year 1 or year 2 or year 3. But they left, but they didn't have much in their background at all. That was problematic, if anything. And they were diligent in saying, okay, on year 4, I'm gonna submit that application. I'm gonna move everything. The committee historically has said, yeah, but you didn't do it on year 1. So the holistic view really was saying that's where the continuously would go, right, under that holistic view. What I see this proposal saying is, in this person's circumstances, that it is in fact objectively reasonable. I'm looking away from the screen because I'm looking at the rule language. It is objectively reasonable for the person to think that 1 year would be sufficient to process their moral character because they have no criminal history, no driving infractions, no honor code violations, no whatever. They've got nothing. And then, so 1 year is plenty of time to process it. And then the pandemic hits, right? And suddenly they can't get their certificate of good standing from the state of Maryland. And they just had no way of anticipating that. So I think by putting continuous in my mind, it takes us back to that holistic approach. And that's what that's what the rule as drafted was trying to get away from, which is why I see this as giving sort of a greater possibility of granting that extension than the current rule.
Well, what's your response to that, if any?
Well, in that sense, yes, but it's also it's a pretty hard deadline. It's saying you have to start, you have to take all the steps by a reasonable period, and it's these extraordinary circumstances. I think they will be relatively few. But if if it's a delay in the bar staff, let's say the bar staff has they're understaffed, or a bunch of people quit or whatever, and that's really slows the processing time. I would agree that's on us. But what we will have done is on our website, we're going to say what expectations are, and also in this rule we're saying that. I see this as sending the message that because one of my concerns about our previous process is the circumstances of the applicant, whether they present a sympathetic case, seem to have a out of the expected influence on what we decided, that this should be more objective, and I see this as getting us to that place. And as far as you're concerned about the word diligent, Alex, it is further defined, by all that language that says you have to take into account how complicated your moral character review is likely to be, and that sort of thing. So it's not as open-ended, in my view, as you might be thinking.
Well, no, I thank you for the assurance. I certainly have to look at the language now. Do we have exact language for one of the slides?
It's attachment A.
Yeah.
And it's 4.17 on page 9.
Yeah, I do find comfort now that I'm, further reading this. Diligently attempted to complete all requirements for admission. So I think the word diligent is modifying the part where they have to put all the requirements together. And so I think given the example that Donna had, obviously diligent wouldn't be applied to year 1 or year 3. It would start at the time when they have to start thinking about putting the applications together and applying to the bar. So that's it. Go ahead.
And it just occurred to me, one other aspect of this, Donna, is when somebody is faced with this this problem, should they be able to wait several years to ask for the extension? I would think not. Should we add in some kind of requirement that they apply for it within some period, 6 months, say, after the 5 years runs?
I considered that to be implied at the very least. Yeah, in my mind, you don't get an extension once it's already expired.
But most of those we consider now are applied for afterwards, I think. Wouldn't it be good to say that? Because that would create a simple out for us. We wouldn't have to wrestle with it if they've simply waited too long.
So we can add a paragraph E at the very end there that says the request for extension must be received prior to the expiration of the 5 years.
I might be willing to give a little time after, but not years or even a year, but because I can imagine people not want, who are teetering on the edge of making it, wanting to see if that's going to work. And do we want to make them file a request that we have to deal with in some way, and I presumably pay a fee before they know for sure that they need to make it?
We certainly had a perfect example of that, Paul, of an individual whose moral character got approved pretty close to the 5 years, like the day after. And then they needed to be certified to the court. And so the 5 years had passed. So giving, what are you thinking? 6 months, within 6 months of the expiration? Is that, I don't want to put any words in your mouth.
Does that seem too much to you? Certainly sometime after, it could be like 90 days or.
So my take on this is, the Supreme Court has really spoken on this issue. The court doesn't want us to grant any extension. Certainly doesn't want us to eliminate this 5-year period. I think the spirit is we need to make it as strict as possible and not allow any potential extension past the 5-year period. And here, my concern now, the request for extension must be received prior to the expiration of 5 years. I do remember in one instance, the last couple of years, where there were applicants where they submitted their request literally a month, if not just shortly right before the expiration. And so I certainly think that this would give them or potentially provide abuse to the system. Because again, I do think a lot of these requests should be received well in advance before the expiration. Right? I think Paul is, speaking to what you said earlier, they need to decide early on whether they want to be if they want to apply for a California bar, and not wait until the eve of the expiration to make that decision. And of course, I think that also puts a lot of burden on the state bar to process their applications. And then, like you said, there's going to be a lot of layers of reviews for certain applicants. And I think if you were to do this without giving them a longer period to meeting well in advance of the expiration, I surmise this could take 6-7 years, and I don't think that's really the spirit of this rule.
So, are you arguing in favor of requiring the appeal or the request for an extension before the period expires?
Well, absolutely, and not just before expiration of 5 years, but we need to set a deadline. Whether it's 6 months or even up to a year, you need to set a deadline. Because like I said, it's going to take some time to process, especially for those applicants with a long criminal history, to process those applications.
Well, I just worry about staff has more processes to conduct. And then the applicant, there is a fee for this, isn't there? Is there not, Donna?
It's not a fee.
There's not a fee. Oh, okay. Well, never mind that argument then.
So how many months would you feel comfortable in terms of, allowing them to apply, but at the same time, not allowing people to abuse the rule?
I'd say a month before. I don't think the court is as worried about, it extending beyond 5 years when they actually get sworn in, as you may be thinking. Donna said that they said we failed to make our case for the elimination of the requirement, but that's being a little generous on her part because they literally said nothing. I think she's surmising from their having said nothing that we failed to make our case, but they literally did not say even that. So we're kind of left in the. It's one of the things I've fed back to our court liaison. The idea that we could use a little more guidance sometimes when they make these decisions. It would be helpful to us to know, what their concerns are and how we could address and therefore address them. But anyway, I would say they have to file it no later than a month before the expiration, maybe.
Do you see my edit, Paul?
Sorry, I was looking at the code on, let me see. Yeah, that works for me. I would be willing to say after, but if to accommodate Alex's concerns, this is acceptable as well.
And I'm also fine with 30 days for now. We'll see. I mean, only the history will tell us whether this is the right number. But right now, sitting here, I think it's okay.
So let me ask Tara, what do we say on the website right now about what the what a completely uncomplicated moral character review, what time that takes?
There's a minimum of 6 months.
Okay. So yeah, it certainly needs to be less than 6 months, because somebody might wait that long, although I would not advise it.
Paul, may I interrupt for a moment?
Sure.
It's about to be 11 for our special session. And so if it's okay with Paul and Donna and everyone, may we take a 5-minute restroom break and then come back and then do our special session with Lisa and Roger? Is that okay with everyone? Okay.
Sure.
Yeah.
So the time now is 11:01. We'll come back at 11:06. Thank you.
Thank you.
All right, everyone. It's 11:06. Welcome back, and we will table the discussion with Donna and Paul and the working group because we have to go ahead and start our special session that was set at 11 a.m. because Roger Bolus that's what his time availability was, and so the item we'll be discussing is action on modifying the first year law students examination to eliminate essay questions resulting in an all multiple choice exam. I'm going to turn it over to Lisa, if that's okay, Lisa.
Yes, thank you, Dr. Cow. Good morning, everybody. Devin, I see that Dr. Bolus is in the audience. Can you please promote him?
Yes, he's been promoted.
Okay, thank you. Okay, thank you. At your August 2023 meeting, Dr. Bolus presented his first year law students examination tracking report called Profiling the Immediate and Long-Term Outcomes of the California First Year Law Students Exam. The report is included with your agenda item as attachment A, and Dr. Bolus is here to answer any questions the committee may have after I present this agenda item. So the first year law students examination is taken primarily by students attending unaccredited law schools and students in the law office study program. It's administered 2 times per year in June and October. It is a 1-day exam comprised of a 4-hour essay section and a 3-hour multiple choice section. Some key findings from Dr. Bolus's report were that the performance on the first year exam is a strong indicator of California bar exam performance. The scores from the essay section were only weakly related to the bar exam scores, and the reliability and predictive validity of the first year exam would be most improved by eliminating the essay section completely. Dr. Bolus also concluded that elimination of the essay section from the exam would not adversely impact any particular groups of applicants. So the key impacts of modifying the first year exam to an all multiple choice exam would be to eliminate the cost of developing the four new essay questions twice each year for each administration of the exam. We do not reuse our essay questions. It would also eliminate the cost of grading the applicant answers to the essay questions. And it would eliminate the reappraisal phase of grading because with an all multiple choice exam, it's subjective and the reappraisal would involve one of our EDGE team members doing that reappraisal. It would also reduce the testing burden on applicants by limiting testing to 1/2 day and reduce the time it takes for applicants to receive their results from the exam because scoring would be basically just scoring the multiple choice section and not having to do the more subjective grading. Allow the possibility of administering the exam more than 2 times per year. That would also be possible. So the proposal to eliminate the essay section of the exam would also reduce the cost of developing, administering, grading. And the estimated cost savings would be approximately $100,000 per year. There would also be additional cost savings that would be achieved from a shorter exam, as well as other considerations. So the committee has the authority to modify the format of the first year law students exam pursuant to admissions rule 4.56. Staff recommends that the committee approve revising the format of the first year exam to eliminate the essay section, making the exam an all multiple choice exam. It's also recommended that the committee direct staff to engage the state bar's psychometrician to take any additional steps necessary to effectuate the modification of the first year exam to a multiple choice exam. So with that, does anyone have any questions for me or for Dr. Bolus?
Yeah. This is Robbie. Hi, Lisa, and hi, Dr. Bolus. I have to say, my eyes got bigger and bigger as I read this report. I was totally shocked. Roger, maybe could you share a little bit? How is it that eliminating the multiple choice or the essay portion, I always thought that was so integral to what we do when we look at those exam scores. How is it that you don't feel that adds any value?
I just, first of all, can everyone hear me okay?
Yes.
Yes.
Okay. The notion of the written section not adding any value is, I think it's kind of an intense interpretation. I have to add that this is the third time that this report has been this analysis has been conducted over the 20 years, and that the findings pretty much have been replicated in each of the administrations. So this isn't just a one-off finding. So the findings are are very consistent. In terms of the notion of adding value, it's all done in the context of what is the stated objective of the first year examination, which is to provide an initial screening of applicants or students at this stage, and that it would be relatively predictive of eventual performance on the bar examination. So that was the context in which we conducted the analysis. We weren't looking at it from the standpoint of any sort of educational objectives that the examination may have had. We weren't looking at it from a standpoint other than the stated objective, which was the predictive ability. Probably the primary reason why the essays don't add a lot to the predictive value is probably twofold. One is there's only 4 written questions, so as a result, the reliability or consistency of the essay section is low relative to the multiple choice test. Whether or not students are picking up some sort of incremental training from taking the essays, we don't speak to any of that. We are mainly looking at this from the standpoint of predictive validity. The multiple choice test in and of itself is for a 100-item test is highly reliable, generally exceeding 0.85 and above, and that's pretty much been the case for the last 25 years. So in and of itself, it's highly reliable. When looked at in combination with the written section, because the written section is less reliable, in totality, the written section actually takes something away from the overall predictive validity and the reliability of the exam. So not sure if that's where you were coming from in terms of your question of value. I think we've got enough evidence now to say the multiple choice test in and of itself would carries the full value of the first year exam by itself.
Paul, you have your hand up?
Yeah, thanks. Robbie, I think you may be sensing that there's a little bit of a loss of practice for the essay portion of the general bar exam, but and maybe that's true a little bit, but given the I think a pretty significant cost reductions that we would gain from eliminating the written portion, and given that that first year test is given to so few people, and therefore if we ever charge them the full price of the product we're providing for them, it's they're going to save a lot. I don't think that the practice value even comes close to the savings that they would enjoy. I have a question about process. The resolution you're asking us to adopt is pretty general, but there are steps to implement this, I presume. Lisa, is there, for instance, a rule that needs to be modified? But I assume you're proposing that you come back to us at some future time to explain further the process and ask us to bless that at that future time. Is that right?
Yeah, that would be the second part of my motion, but I don't think would require any further rule changes. At least I don't know of any. There would probably have to be some kind of another standard settings, and well, not a standard setting study, but trying to determine what the proper passing score would be for the new all multiple choice exam. We've discussed this with our psychometricians, and there is a plan, a pretty comprehensive plan that they've worked out for how this transition would occur. All of it very, psychometrically sound and valid. So that is something that once we get approval from the committee to go down this road, it is something the psychometricians have a plan for implementing. And so I imagine that, along the way, to the extent that we need the committee to, approve certain things, that this will be brought back to you.
I guess I would prefer that you bring back a proposed plan rather than just as necessary, so that we can review it first before it goes into effect.
I would add, and I think I brought it up when I did presentation at the last committee meeting, the current passing standard on the exam was set just about 25 years ago. And psychometric practice suggests that standards be reevaluated generally within 7 to 10 years, depending on the criticality of the decisions coming out of the testing. So whether or not the committee decides to modify the examination structure or not, a standard setting activity is probably warranted. Especially given all of the changes that have occurred in the landscape of the unaccredited schools since 2000, when the examination was kind of restructured.
Okay, so yeah, that just reinforces my notion that a report back to us would, including review of the cut score, would be appropriate before anything is actually implemented.
Alex, I see your hand up.
Yeah, thanks, Roger. The comments are very helpful. One of the issues that I have is as part of your analysis. I think earlier you said because there are only 4 essays, the reliability is low relative to the multiple choice test. And so as part of an analysis, now that literally this is the first time I heard about this in the last 6-7 years I've been on the committee. Have you considered perhaps, well, to improve reliability, maybe we need to have more essays versus just eliminating that section altogether? If truly reliability is the question, then perhaps have you really considered that as an option?
Yeah, a couple of things. The current overall reliability of the examination meets psychometric standards for the intent of the exam. So kind of start from there. If I did not look at the incremental reliability, and it's possible to look at the incremental reliability of, say, adding 4 essays or a few more essays on the exam. The reason why I didn't look at that is was looking at it in the context of could we achieve a relatively similar reliability on examination without adding burden to the test taker and to the committee. The question of whether or not the this type of examination needs a written test is a little bit outside of, you know, of my bailiwick. That becomes a validity question, and we do know, in the way I looked at validity was relative to bar passage. I mean, this was the stated intent of the examination. So if from the sake of efficiencies, if I can achieve a fairly predictive test by shortening it in some way, that's what I'm going to do. You know, if the committee said, well, we should probably add to the test and add to the burden, the question would be, A, why would you want to do that? You know, what value do you perceive additional essays bringing to the table? Then there's some sub issues under that. Is could you can you create as reliable additional questions on every administration, and and achieve a greater efficiency, I would suggest, than what we have currently. So, long answer to your short question, I did not look at adding essay questions to the exam.
I appreciate it. I think the issue about burden on the applicants, by the way, has never been an issue that comes before the committee. I certainly have never heard about that, you know, a heavy burden or undue burden being placed on the applicants resulting from the first year law bar exam. But that being said, my bigger concern is how your analysis would be interpreted in the context of the general bar exam. Now, I don't think this is your intent, but there is certainly this appearance or optic that the essay portion, right now you're saying the essay portion is not reliable, how that would be translated or misinterpreted, that perhaps the same essay portion of the general bar exam is similarly not reliable. And really that's going to be driving my thought process about, you know, whether we should eliminate this. And by the way, I'm not disagreeing with the objectives, but I certainly get a sense that the more I'm hearing about this, it seems like the motivation, the driving force in the context of getting rid of or trying to get rid of the essay portion is it's a financial one, because it could potentially save a lot of money. And even, and this has had something to do with you, Roger, but I'm just looking at the benefits. I mean, I'm looking at the benefits. It seems to me that the first couple of benefits are really monetary or financially driven. So if that is the case, I just don't, I don't think the reliability is really the core issue here. And by the way, if the current passing standard was set 25 years ago and we need to reevaluate, then we should. And that means we need to consider not just eliminating it, but perhaps to increase the number of essays, not to reduce it entirely. So that's just my 2 cents.
Alex, can I address a couple of items that you just raised right now in terms of some of the objectives that we're trying to meet here with this recommendation? In terms of it being really fueled by cost concerns, I think that's part of it. I think that you know, this is the agenda item today is from the presentation, stems from the presentation that Roger did at the last meeting, and his data was really over about I think a 10-year span. So this is you know, not recent data. This is something that has been reviewed over quite some time. Later on, I'm going to give an update on the number of people that are going to be taking the October 2023 exam, the upcoming first year law student exam. And I've reported this, you know, I reported at every, we've reported at every CPE meeting, and that is the number of people that are taking the exam on an annual basis. We are that number is going down annually, and it has a lot to do with the number of accredited law schools. And so part of it too is looking at that. So aside from cost, it's also like the efficiency of how we support this. So I think you're simplifying the idea that this is just all cost driven. It's also about, the effort to put this together. I think if you look also within the summary itself in the agenda item, when we discuss the alternative, which the alternative to eliminating the essays is to change the weights. And the weights, the more you give weight to the multiple choice, the higher the reliability of the exam. Is an indicator of efficiency as well. So I think, at some point we're going to talk about a mandatory accreditation. And within that context, I think that it makes this recommendation a little easier to understand. It sounds very like a big jump, but I think that in the context of all of that, and once we have that discussion, I think it makes more sense. But I just really want to show you that it's not 100% cost driven.
Thanks, Amy. By the way, I want to make it clear, when I say cost, I'm not saying it's not a sound. It certainly is a sound objective. If one of the objectives is to eliminate cost, then it's fine. By the way, do we know how much money we would save, the state bar would save by eliminating the essay portion? Because I don't think I've.
Yeah, it's in there. It's roughly over $100,000 a year.
Okay.
There is a one of the pillars of testing, in addition to notions of reliability and validity. It is one of efficiencies, and it's generally incumbent upon a test administrator to ensure that a couple of things. One is that there's appropriate coverage of material for the stated intent of the examination, but two, that there is efficiency in that assessment process. And to the degree to which one could document that, one can arrive at consistent decisions with fewer components. It's kind of incumbent upon the test administrator to really justify not excluding something, but actually including materials as well. And if it's established that the some component isn't really adding anything to the decision-making process, then one has to start considering, what are there may be other reasons for inclusion of another component. And Alex, I think maybe that's where you were going, is if there's some perceived subjective reason for having an essay component on the examination. And again, that is kind of more of a subjective discussion, not necessarily a psychometric one.
I see Justice Mesawala, your hand is up.
Good morning, Dr. Bolus. I'm new to the committee, and I really enjoyed reading your analysis of the first year law school exam. I was struck by one part of the analysis that talked about the key data, and it said, it's on page 3, and it says the essay scores on the first year law students exam not only added little to the predictive value, but actually may reduce it. So to me, that really struck at the core of the problem here, right? Is if we are using these essays to help us decide which students will end up matriculating and passing the bar, and the essay portion actually reduces the predictive value, then what's the point of it? Can you explain how it reduces the predictive value, or how it may reduce the predictive value?
Yeah, it's a bit involved, but the idea of when you have a total score, which is what comes out of the first year exam, which was a composite. It's a composite of the multiple choice score and of the essay score. And the once those two scores are put together, we always look at the what we did in the report, at least, was to look at the relationship of that total score to the final performance. And what happened is when you have a component of an examination that is not reliable, basically what we're I shouldn't say not reliable, but not as reliable as the second component, it can actually detract from the actual relationship with the target. In this case, it's the bar examination scores. So as scores are, you can in an extreme situation, you could take a test that has absolutely no reliability, which means it's adding absolutely zero to it. So, and if you're giving it a weight, in this case, we're giving it a weight of 50%, that the relationship between the composite at that point and the eventual bar exam would be much worse than it is. So as you move down from a perfect reliability, which means the decisions would be totally consistent from one administration to another, from where it is currently, you start minimizing the amount of additional information that component of the test is going to add to the exam. The fact that we currently weight this much less reliable essay the same as we're weighting the multiple choice, which again stands alone almost in and of itself, achieves the standard of what we would expect for a test doing this type of prediction. We start detracting from its predictive value.
Thank you, Dr. Bolus.
Vince, I see your hand is up. You're on mute, Vince.
How many years have I made that mistake?
Justice, excuse me, I might add that the analyses, in a sense, what I just gave you is a bit of a theoretical argument. We followed that line of thinking in the actual analytics that we did. So if you got into the meat of the report, which I apologize in the sense that there's a lot of statistics in there, but if you get into the section where we looked at the relative predictive value of just the multiple choice by itself, we actually looked at the data and followed that line of thinking to see, well, what would have happened in terms of consistency and a definition of who's passing and who's failing. We were able to pretty much document that was the case because of the unreliability of the essay. It might have over predicted a pass for some people, under predicted for other people. So it wasn't doing that consistently enough to carry the kind of value that it's being given presently, vis-a-vis the prediction of success on the bar exam. So there's a lot of data tables in there to document that, the theory.
And that makes sense to me. Thank you, Dr. Bolus.
Thank you, Vince. We'll go back to you.
Yeah, thank you, Mr. Chair. First of all, Lisa and Dr. Bolus, thank you for such a intense report. I'm going to ask a question that maybe has been tread over for a long time, and it has to do with racial bias in testing, and it may be out of the scope of what you've done here, but I was looking at the, all the charts you had on racial and ethnic breakdowns. Do you think that eliminating the essay has any effect, either positive or negative? Because the passage rates on most of the ethnic groups, Black, Hispanic, Asian, are much lower relative to the passage of whites taking the test. So how much of that is considered in eliminating the test? Is there any effect on that, or was that in your scope of inquiry?
Yeah, Lisa, you can talk to it first. I can add anything.
Yeah, if you look through it, there's a I think it's the qualitative data. I can't remember. There's part of my agenda item that just briefly summarizes Roger's findings. And that is basically that he did not find any substantial adverse impact to any particular group of applicants, and that would include the ones that you're talking about. So, in terms of the statistical analysis or data that was used to do that, I will defer to Roger in terms of how he arrived at that conclusion. But I summarized what came out of the report. And
yeah, Vince, I've been doing this for quite a few years, and I know eventually somebody will ask that question. And so in the simulations and the analysis, we took into account the race, ethnicity of the applicant, and such that after we looked at the effect of with the percentage of people passing and failing the examination, first of all, just the first year by itself, and then eventually those taking the general bar, if we were to go down path B, which was a multiple choice only, with the discrepancies between the performances of the races, so white versus Hispanic, white versus Blacks, Asians, and kind of the general population, would those get bigger or smaller if we were to do it? Because if the discrepancies were to get any larger, then we might perceive that there was some bias in this decision. But all of the analyses that we conducted showed that by doing this, it would not statistically negatively impact any of the minorities, nor would it enhance somebody's chances of passing. And to the degree that it would be consistent for all of the racial ethnic groups. So in a sense,
thank you.
Yeah, this decision would be kind of agnostic to race or ethnicity.
Okay. Yeah, thank you. Because I realize there are many other factors that go
for
into
sure.
Performance of minority groups. I mean, admissions and all that kind of thing takes in consideration. So I was just concerned that any changes to the test don't affect it as is, if your psychometric sort of detailed that it's been sort of a level playing field up to this point.
It's a good question. And it's one, when you approach an analysis, especially in this area, you just have to be extremely mindful of.
Yeah, thank you.
Are there, Kareem, I see your hand up.
Yes. Thank you for the analysis, Dr. Bolus, and thank you for your continued rigor on approaching a lot of these interesting insights that we're looking to capture with this test. So we saw, I'm of the age where I went through a different SAT. We saw the SAT expanded through an essay incorporation, and then we saw the essay portion kind of more withdrawn over the years, and then moving back to its old status. And so as I'm hearing the conversations and the analysis that you provided, I'm also considering the CAPA survey that we did, and a couple other studies we did where there's a need, I guess, on the competencies of critical thinking and how that integrates with the actual role itself. So I guess the way I'm processing this is that the reliability of the essay is not as effective in measuring those competencies. Or is there another path forward on measuring some of those competencies that we're seeing from the profession, but then also looking from a standardization testing procedural approach?
Yeah, the only thing I can comment, Kareem, on that is that the essays are constructed within a set of rules. And so I'm aware of your CAPA study. Whether or not the essays capture any of those additional or incremental skills that were out there, Lisa would have to speak to. But looking, again, the approach or the methodology was to look historically and to ask whether or not historically, if those exams had been adjusted without the written section, for many years, the examination could have continued quite effectively without the written section. Now, if the rules change, that all of a sudden we're looking for an examination that is now intended to start addressing other content areas, then I would suggest that these results would they stand alone and they're effective, but now you're basically changing the rules, and then it begs the question is what this examination would look like, and perhaps you would require to have it would be required to have essay questions in place to now measure these new skills that you're talking about. But that's a different examination.
Yeah. So is the assumption could be made that the current essay portion is not examining the current rules? Is that kind of the overall analysis?
No, I think it's doing it. It's just not doing it as effectively as the multiple choice section is doing it. I did not spend any time going in and disentangling the content of the questions and saying, could you improve the questions to do that? All I know is that the decisions, this is 20 years worth of data. So it's not like this one particular year, it wasn't doing something, but for 5 years it was. This has been very consistent for the time being. And the recommendation, again, just to consider, was clearly from a psychometric standpoint. I didn't go in thinking about, at least I personally was, when I was running the analysis, wasn't thinking that, the bar exam could say, the state bar could save a lot of money doing this. I went into it as a psychometrician would be talking about it from standpoint of efficiencies.
Yeah, and I think to add to that, Kareem, I think if you were at at the August meeting where Roger presented his PowerPoint and some overview of the purposes or the historical reasons for having the first year exam, and then it's going into its predictive abilities. I think that in terms of this decision or recommendation to eliminate the essay section is more geared towards the increasing the or addressing the predictive ability of the exam. And so in terms of the relation to the bar exam and what we're trying to achieve there, I think it's a different a different purpose. The first year exam is not the same purpose as the bar exam would be. So we do have the way we develop and design our exam essay questions. We do have, guidelines that we work with, and a team of expert people that we work with. So, we do have the essay instructions of things that we are looking for in terms of analytical ability and, ability to, relate to the facts of the question to the law. And so it's not that the essay questions that are designed for the first year exam are less looking for that. It's I think in terms of the recommendation to eliminate the essay section is more what Roger was looking at in terms of his report and tracking the eventual outcome of what happens with these people who take the first year, and whether or not they have success, and predicting the success on the bar exam eventually.
Okay, and so I had a misinterpretation in my head. This is first year law exam, not the bar exam. And so that's interesting, because the first year law exam is one of the metrics we use to indicate whether a student could continue on in their legal education. And so a lot of our minimum bar scoring requirements feed into that. So I could see where Dr. Bolus is referencing, if the rules change, then it creates the different dynamics. So yeah, thanks for clarifying that. I had to reread when you said first year, because I was looking at this way differently. But thank you for the very wholesome response, and thank you, Dr. Bolus, for your analysis and just looking at it from different lenses and giving that honest feedback, because I'm very adamant about ensuring we're protecting the public, and a part of that is putting in some of these measures that hold us accountable, the law schools accountable, to the public. And so having this information kind of gives us better guidance on what's working, what's not, and what we could do to improve. So thank you both. I appreciate this work. It's really amazing stuff. So thank you.
Yeah. I might add that in the report, there is some analyses that contain information that suggests that at certain levels of performance, the subsequent probabilities of performing at a level that would allow a student to pass the second or third time, or even pass the bar second or third time, we've quantified some of that. And so, Kareem, I'm just reacting to your comment about protecting the public. There's information which would have to be worded quite carefully, but that would might educate somebody who's on the fence about, should I be continuing on? What should my path be at this point? There is some information in there that might help an individual in terms of making that decision. And that's independent of whether or not the examination is two modalities or one modality or.
Hey, this is Robbie. Dr. Bolus,
Yeah,
I'm so sorry I got cut off right when you were helping me out with my question, and thank you very much for putting the time in. I was a little taken aback by your report, and I'm glad to get a little bit more of the background. Lisa, I have a question for you. Can an applicant for the first year exam pass that exam by doing well on the essay portion and poorly on the multiple choice portion? Can that rescue an applicant who does not fare well in the multiple choice section?
Yeah, I think so. Just like for the bar exam.
Because I'm a little surprised. I must not have realized that this was in the works, because I don't remember us ever talking about this while I've been on the bar exam, but on the CBE. But I feel like the essays are an integral part of a student's opportunity to display their competence. Maybe a student who does not fare as well on a multiple choice format. I feel like we hear that in the context when we talk about the regular bar exam. And when I was on Kappa and we talked about different ways of measuring competence and giving students an opportunity to display their abilities, I felt like the essays were a big part of that. And now that Amy has revealed the savings as such really are not earth-shattering in the overall scheme of the bar budget. I say let's keep them. It sounds like you say let's drop them.
Yeah, I want to clarify Lisa's comments a little bit, and then that's always an issue. Is, well, if they perform well in one section, will they perform well enough in another section as a compensation?
Yes.
The degree of relationship between the multiple choice test, the multiple choice score, and an essay score generally runs on an index of 0 to 1, generally runs somewhere between a 0.6 and a 0.7. And so that means if you look at the relative rankings of individuals on the written section versus the multiple choice sections, they will tend to rank order relatively close. So one asks the question is, well, do you, again, and this is all from a psychometric standpoint, I'm not speaking again from the substantive standpoint, but to your point is, can one test rescue the performance on another test? And in the main, the performances on the respective sections are pretty close. So while there may be a handful of people that would pass under, if there was an essay versus not having an essay, it's very small. It's very small. And the analysis in the report, because that, again, that's another question that's always asked is, well, what would happen to eventually to their passing status? Very few people would change their passing status if we were to eliminate one of the portions of the examination. Very few, and it's just a handful of people who tend to be right around the passing point. But there are very few people, if any, where they perform extremely well on one section and extremely poorly on another section. So the concept of using the essay as a rescue instrument probably doesn't carry a lot of water here. And I forgot which table offhand in the report, but the report kind of speaks to, the consistency in the decision making if you were to eliminate the essay section. I had done some back of the envelope calculations that showed that was not the case if you were to eliminate the multiple choice and keep the essay. There would be an awful lot of bouncing around there, and that's probably because the essay lacks the same reliability that the multiple choice test has.
Thanks, Dr. Bolus. I appreciate the clarification.
Dan Bolton has a question.
Go ahead, Dr. Bolton.
Yes, I want to know if Dr. Bolus will tell us the difference in the cognitive skills used in the multiple choice test and the cognitive skills used in the essay test. What's the difference in those cognitive skills?
Yeah, I would defer to Lisa in that as the test constructor.
Yeah, I'm not, can you, Dr. Bullis, can you, sorry, Dr. Bolton, can you kind of give me more detail on what you're looking for in terms of cognitive scale?
Well,
Skills, I think he
Oh,
said
skills.
skills.
In the cognitive domain, there are memory, knowledge, synthesis, comparison, analysis.
Yeah.
And I want to know the difference of those skills that are being used in the two different essays.
Yeah, you mean the essay section versus the multiple choice section?
Absolutely. That's it.
Yeah. Yeah, I mean, I would think that you would have to have the same, I mean, the multiple choice questions are you know, constructed using, I think requiring a lot of the same skills that the, in terms of memorizing or, you know, and applying what the rules are to the facts that are presented in the question. Analysis that you would do normally on paper, you know, for an essay question, you would probably have to do in your head for to answer a lot of the multiple choice questions. I mean, the skills that you're exhibiting on an essay question are that you're showing your work, right? You're having to do the analysis and putting it on paper to show how you got to where you got. Whereas on a multiple choice question, you may have to use the same skills to get to the same result, but you don't, you select the best answer, the A through D. And in terms of, you know, writing skills, you, in the essay question, you would also demonstrate that by what you put on the paper rather than, you know, in an essay question, I mean, in a multiple choice question. So multiple choice questions, you definitely not be showing your writing skills, but you would still, I believe, have to use the same mental skills in terms of your analysis and, you know, coming to the right result in which, so I does that answer your question?
Yes, it does. Is there a difference in the purpose of the two exams? Do they have a different purpose or the same purpose?
No, I think they have the same purpose. I mean, well, for, you know, so for example, for the bar exam, we're looking for minimum competence. For the first year exam, that's not what we're looking for. We're looking for, you know, does the student or applicant have, you know, have they demonstrated the knowledge necessary to, you know, to go on in their law school studies.
Okay, thank you.
Alex Chen, you've had your hand up for a while, so I apologize, Alex. Thank you for your patience.
No worry. Thank you, Chair. Dr. Bullis, earlier, I think you mentioned that this proposed change could be made without, you know, adverse impacts on any particular group of applicants. Your report also concludes that there are no discernible differences observed between genders. But at the same time, your report says Blacks were somewhat less likely to pass than the other racial ethnic group, though also according to you, there was insufficient data to determine the root cause of that difference. With that said, in going through your report, I am able to find charts correlating the scores for the first year law school exam to the general bar exam. And you also have charts comparing the performance of the first year law school exam cohort on their initial bar exam attempts. But I'm not able to find any chart that conveys the predictive passing rates by gender and by racial ethnic group if the essay portion were to be eliminated. Can you point me to this chart to the extent it exists? If it's not, would it be something that would be overly burdensome to prepare? Because I do want to see, you know, what the likely passage rate would be if we were to eliminate the essay portion.
Yeah, I don't. Let me just see if I can find something quickly offhand. I don't think I delineated actual predicted bar passage rates. I believe what we ended up doing was we modeled that through a technique that looks to see whether or not selected factors have an impact on that, and didn't find much in the way. There'll always be, with these kind of volumes of numbers, you'll always find things that may be statistically significant, but not necessarily substantively significant. So I believe those things are basically the actual means and things are captured inside a statistical model. And given where we were in the analysis, we thought we didn't want to go down a path just to kind of document specific descriptive statistics when we knew the model showed that the racial ethnic effects were minimal, if any.
Got it. I still understand the differences may be minimal, but I don't know about other community members, given that the potential impacts on different racial ethnic group, I certainly personally would want to see a chart that compares at least the passing rates for the first year parts. The passing rates for applicants within different racial groups. Again, I'm only speaking strictly in the context of the first year law school exam and not the general bar exam. So maybe this is, I'll punt this to Lisa. Perhaps this is something that can be done quickly. I would appreciate that.
It could be done, but not necessarily quickly.
Okay.
Yeah, the report was written actually a couple of years ago.
Got it.
So,
but
sure it could be done. It could be done, but not necessarily quickly.
Understood. And thank you for confirming that. I know a couple of community members, especially me, I'm very interested in seeing the potential impacts on gender and racial equity. And I appreciate your opinions that it may have minimal impact. I still want to see what the differences are and how minimal is minimal. That's all.
Yeah, I understand the question.
Paul, I see your hand up. Paul, I think you're on mute.
Yeah, thanks. So Dr. Bolus, do you think part of the difference in the reliability of the written versus the multiple choice is that the multiple choice covers a much broader range of legal principles than 4 essay questions can?
Yeah, a basic psychometric principle in measurement is that the more observations you have in developing kind of a score, the more reliable it will be, because you have, in a sense, you've got 100 observations in the multiple choice, and you have 4 in the essays, and the scale in the essays are basically only about 12 points, and so the breadth of coverage is much larger in the multiple choice, and the reason why you put an essay question in is to be able to assess incremental skills. But the fact of the matter remains is that the core skills being measured by both instruments are pretty close, as evidenced by that 0.65 to 0.7 correlation. So the reliability, as you've pointed out, it's basically only 4 questions. So there's sources of unreliability come from the questions themselves. It's could be the scoring rubric or the grader. So there's multiple places where unreliability can enter into it. There's essentially an objective test like a multiple choice. It's either right or wrong. So there really is there's no areas for unreliability there.
Thanks.
Are there any other additional questions or comments for Dr. Bolus or Lisa from the committee? If there's none, I actually have a question, Dr. Bolus, myself. You had mentioned in your initial presentation that this is the 3rd time that this analysis has been done.
Yeah.
What happened to the previous 2 times? So was that presented to the CBE? And I guess maybe this question may go to Lisa then, is what were the arguments? Because we know that we're still using the essay and the multiple choice right now. So if I could ask on that.
Sure, I can answer. So I've been on the staff for about 10 years. And then before that, 11 years. And before that, I was on the committee for 4. So in the time that I have knowledge of, I believe that the this particular issue and motions came before the committee one time. So before that, it may have come another time, but I don't know what the outcome of that was. Obviously, what the outcome was, the exam stayed the same. But my recollection is that when it came to the committee the last time, is that you know, many of the committee members, or enough of the committee members, wanted to keep the essay section because of the feeling that it was something that, a skill that, you know, testing skills that we should test on the first year exam. So that was my recollection, is the main reason why it didn't pass muster the last time.
So Lisa, so this was last discussed as an agenda item to the committee about a decade ago. And then
Maybe 5 or 6. Yeah, I don't remember exactly.
And then the reason why we're bringing it up now, if you could clarify.
Well, Roger recently, he redid the analysis.
Okay.
Sorry, Lisa, not to.
No problem. Same result though. Same result in terms of the analysis. So, you know, different committees have different compositions, and you know, it's in the past, the majority of the committee didn't want to get rid of the essay section. So, you know, it's possible this particular composition of the committee is interested in doing that. So yeah.
I think it's a long time ago, and my predecessor might have actually done the first presentation even longer than that. But my recollection is that there was some belief that there was an educational value or diagnostic value to the written portion of the examination. And I think in the report, I point out that there may be some other values, but that's clearly not one of them, because of this lack of reliability in the essay. Somebody could infer, if they thought that they did particularly well on a torts-related question, that they have some sort of competencies in torts, but the lack of reliability would suggest that they could probably take another essay question on torts and probably not perform as well on it. And that's what the notion of reliability is consistency of the measurement. Just didn't have sufficient. So I pointed that out in the report, but your decision, you know, to retain or not retain the written section shouldn't rely on at least on that argument.
Thank you very much, Dr. Bolus and Lisa. Are there any additional comments or questions for Dr. Bolus and Lisa from the committee? Looks like none. So we will follow the Rosenberg rules. So what we're going to do is we're going to call for a motion.
So I have a motion. I have from the agenda item, if you want me to share that.
Yes, if you may, Lisa.
Sure. Can everybody see that?
Yes. So
I'll make the motion with the modification at the end of the further move, that the staff report back to the committee with its recommended next steps.
I'll second that. This is Alan.
So first by Paul with the modification as stated, and then second by Ellen. So with a first and a second, we will go ahead and have a discussion about this.
Paul, can I have you repeat that, please? Back to the staff of the committee.
Yeah, I think it needs to go at the end of the motion. because we first have to direct you to work on the project, and then we want you to report back for our consideration.
Or a recommendation, I think. Oh, that's good.
I'm sorry, report back to the committee.
For a recommendation?
For our review and approval. The idea being the details matter, and we want to see those before this thing goes live. Do you agree to that, Alan?
I do. I was wondering, should we say report back to the committee with an implementation plan
Even better.
for the committee's review and approval?
That look good?
Yep.
Yes.
So that's Paul's modification, second by Ellen. So we can open up this modification proposed motion to discuss or debate about it.
This is Robbie. I want to say this kind of discussion that we've just had is why I like the Committee of Bar Examiners. I mean, I think it's very healthy to air these, and gosh, everyone from Kareem to Lisa to Alex has really added a lot to this conversation. Honestly, although generally whatever Lisa Cummins says, I agree with. In this case, I don't think the burden of the essay portion of this exam is outweighed by the potential benefit to the bar and its review and to the applicant who's taking the test. So I'm going to be voting no, and let's keep our exam, our first year exam, the way it currently is devised. And thanks everyone for such very healthy discussion on this issue.
I have a question, Chair. Is there, should we put a deadline or anything on this? Because I know that, if we're thinking about an implementation plan, when would that actually start with, a new testing plan going forward?
That's a great point. So that is something that, are you suggesting a friendly amendment to the motion then of pause where we give a deadline then? And do you have a deadline in mind then, Vince?
No, I don't have a deadline in mind. I think I would leave that up to the committee. I don't know if it would be an additional friendly amendment, but just something put, another sentence tacked onto the further move section. No later than, I don't know, 6 months or whatever. I don't have a date proposal at all.
I just wonder if we need that. Staff will work on it in the normal course. In my mind, there's no particular urgency to this.
And then the actual implementation, the timeline for that would be part of the plan, I would think.
Okay, I'm good with that. I just didn't, wanted to linger and we revisit this in another 2 years or something. So.
Yeah, and we'll need to make a note if this passes to put it on the work plan.
That's what I was going to say. We can put it on the work plan for next year.
Okay.
I have Kareem's hand.
Kareem, I see your hand up.
Yes, thank you, Dr. Cow. And I also want to thank the fellow committee members for their comments, and also Dr. Bolus and Lisa for their transparency and kind of how this all integrates with the work that we do on the committee. This motion before us is going to be to move with the newer format. Yes, all multiple choice examination. So in my opinion, I think the research has been done I believe that, we're at a very key point and an opportunity to kind of pave a new way. And so I'm hopeful that we do move in this direction. We add it to our work plan and we see how this works. I think the research that we have is informative, and I think it showcases kind of how we've been doing things and what our results have been. And so it's definitely a good move forward, in my opinion. And so I just want to thank Dr. Bolus for really narrowing and looking at it from the perspective that he used for his study and the methodology that was utilized. So thank you.
Hands up. Are there any other? Ellen, sorry. Ellen, could you go ahead and?
Yeah, thank you. I just wanted to say, going into this, when I first saw the agenda item, I frankly was in agreement with Robbie's position. I thought the essay portion is important to measure an applicant's skills and to predict and to tell them, to inform them how well they're likely to succeed in law school and eventually on the bar exam. But apparently the studies don't support that. And that's why I've come around to the position that there are benefits to eliminating this, and we should go forward in this direction.
Thank you, Ellen. Any other comments or discussions about our modification to the proposed motion by Paul and second by Ellen?
Yeah, this is Alex. I think the only concern I have that I really didn't get to address earlier is that we call it the CAPA study that a lot of us are probably very much familiar with by now, that it calls for drafting and writing skills as one of the essential areas of focus in determining competency. And part of this is part of the reason is because we want all the law school students and applicants to understand what writing requires. As a lawyer, you need to know how to draft documents, you need to know how to write briefs and motions. I am just concerned that by getting rid of the essay portion, you're basically giving these students and potentially all the accredited schools the jail-free part to not help them improve or perfect their writing. And I for all of you who understands the law apprentice programs, there we have students actually applying to take the bar through the law apprentice programs, and so they don't necessarily get the traditional law school education that we all get, right? And so without education from law schools on how to write, how to draft, and just be a good writer, I'm just concerned that this motion, which I still think is too fast and too furious to happen all at once so quickly, is going to do them more harm than good. And so for that reason, I think I advocate what Brody is saying. Is this is just too much at once, and I just don't think this is going to benefit anyone in the long
run. Mr. Chair.
Yes, sir.
Alex raises a good point. It's a broader point, though, in my mind. To this point, we do not review the quality of writing, proper grammar, spelling, punctuation in essay exam answers on the bar exam, and the CAPA proposals, the BRC proposals are going to make that, I think, an element of bar exam grading. So not so much just for this exam, but for the bar exam and for real life, I think we maybe need to think about what we can do to help law schools improve the writing of